jump back on our live readings of the Constitution, and today we are going to start where we left off with Article 3, Section 2 of the Constitution. Um, let's do this. Okay. I'm Finley, your host. I am a United States Navy veteran. I served from 1998 to 2001, and I was stationed at Naval Station Norfolk. The important thing for you to know at this point is that I have read the Constitution multiple times. I'm not a constitutional law scholar. I'm an average American, and I understand the English language. I utilize things like the Johnson Dictionary in order to understand what our founding fathers may have meant, utilizing the dictionary that had definitions they used during their time. So we're going to go ahead and start now. Article 3, Section 2. The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made or which shall be made under their authority. To all cases affecting ambassadors, other public ministers, and consuls. To all cases of admiralty and maritime jurisdiction. To controversies to which the United States shall be a party. To controversies between two or more states, between a state and citizen of another state, between citizens of different states, between citizens of the same state claiming lands under grants of different states, and between a state or the citizens thereof and foreign states, citizens or subjects. And this also has an asterisk saying that it was changed by the 11th Amendment, which we are not in the amendments yet. We're still in the articles. So we'll get to that and we'll learn about what change was made. But when this was originally written, the judicial power extended to the laws of the United States and treaties that were made, to any cases affecting ambassadors, public ministers, or consuls, so people who represent the United States, and to controversies to which the United States shall be a party, and to controversies between two or more states. So federal law is when we enter between two states their issues. And then also between a state and citizens. So federal law kicks in when a state's laws are not adequate to deal with the two issues, that being the federal government or a foreign government, or the two states or a state and a different state's citizens. This is when federal law kicks in. Otherwise, it's left to state laws. Okay, so we're going to continue. In all cases affecting ambassadors, other public ministers, and consuls, and those in which a state shall be party, the Supreme Court shall have original jurisdiction. In all other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as Congress shall make. So we're going to stop right there for a second. That rule right there says that Congress determines how the Supreme Court has actions. What does that mean? Well, the actions have both law and fact that the Supreme Court deals with, specifically in an appellate jurisdiction. When we're talking about ambassadors, public ministers, or consuls, the jurisdiction is the original. It's not an appeal. It starts there. It doesn't start anywhere else. Okay. So then when we go and Congress shall make the exceptions under these regulations, that means that it is not the Supreme Court that decides what exceptions they do or don't deal with. It is the Congress that describes that. Hey, man, welcome to the club. So we're going to continue. The trial of all crimes, except in cases of impeachment, shall be by jury, and such trial shall be held in the state where the said crime shall have been committed, and when not committed within any state, the trial shall be at such place or places as the Congress may by law have directed. So this is, again, the Congress is doing the direction here. It is Congress's job to make regulations. It is Congress's job to set up the exceptions, and the judicial power is supposed to be reading the law and applying it. They don't make it. We have seen them making it in our lifetime, which means they're not being constitutional. So we don't have a constitutional Supreme Court. We have a whatever the fuck they want to do Supreme Court. Pardon my language. So finally we go, the trial of all crimes except in cases of impeachment. So right there, that says there's a special way they handle impeachments, and it's not by jury, but that trials shall be held in the state where the crimes were committed. So when the state of Georgia was suing for the violation of their state election laws, that was supposed to happen in the state of Georgia, and it did so because of this ruling here. So now, Article 3, Section 3, treason against the United States shall consist only in levying war against them, or in adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless on the testimony of 2 witnesses to the same overt act, or on confession in open court. The Congress shall have power to declare the punishment of treason, but no attainder of treason shall work corruption of blood or forfeiture except during the life of the person attainted. What this means is, first and foremost, that we have what is considered treason written out. It shall consist only in levying war against the United States, adhering to their enemies, giving aid and comfort. So every time a senator or a person who is not in Congress does something that aids war against the United States, they're guilty of treason. Now, they are not convicted until such time as 2 witnesses of the same overt act testify in court, and or a confession is given in open court. But the Congress has the power to declare the punishment, and that has to happen within the lifetime of the person who has attained the status of traitor. Now, we attain the age of 21, we attain driving age of 25, and when we reach 25, we attain insurance that we didn't have before. Now, we're talking about attainment as something that can be gained through an action, specifically levying war against the United States. So that's the entirety of Act 3. It's Article 3. It's sections 1, 2, and 3. It starts with the judicial power, and it ends with what treason is. Treason is war against the United States. It is doing things for the enemies, and it is giving aid and comfort to the enemies of the United States. So when we see troops being deployed in United States cities that are not actually in the middle of riots where the governors of those cities haven't asked for help, then what we're seeing is the military being used to war against American cities, which is actually against the Constitution. So everything that we're seeing there is not constitutional, because waging war against Americans is how you become guilty of treason. Article 4. Full faith and credit shall be given to each state to the public acts, records, and judicial proceedings of every other state, and the Congress may, by general laws, prescribe the manner in which acts, records, and proceedings shall be proved, the effect thereof. Section 2. The citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. A person charged in any state with treason, felony, or other crime, who shall flee from jurisdiction and be found in another state, shall, on demand of the executive authority of the state from which he fled, be delivered up to be removed to the state having jurisdiction of the crime. That is an extradition rule that says that when a attorney general of one state asks another state to hand over somebody who has fled, that the other state has to do it. No person held in service or labor in one state under the laws thereof, escaping into another, shall, in consequence of any law or regulation therein, be discharged from such service or labor, but shall be delivered up on claim of the party to whom the service or labor may be due. This was changed with the 13th Amendment, and this is the no runaway slaves law. What this says, this is Article 4, Section 2, and it says that if you are a contract laborer having been bought and sold or having signed your name and you decide to flee your contract holder, you can be chased down and arrested and delivered back to the person. They changed that in the 13th Amendment, but as of the writing of the Constitution at the beginning with the founders, they put a runaway slave rule into place right next to a treason rule. And the treason rule says if you committed a crime against the United States or any state, and then you run, that state can ask for you back. And then right below that, they said also if somebody has a claim over your labor and you run, they can get you back. New states may be admitted to the Congress into this union, may be admitted by the Congress into this union, but no new state shall be formed or erected within the jurisdiction of any other state, nor any state be formed by the junction of two or more states or parts of states without the consent of the legislatures of the states concerned as well as of the Congress. That means that California's plan to split into 3 states would have to be approved by the California legislature as well as the Congress of the federal government. The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States. The Congress shall have the power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States. And nothing in this Constitution shall be so construed as to prejudice any claims of the United States or any particular state. That literally says that Congress is the one who gets rid of American territory, makes rules for the territory. Any property that belongs to the United States has to go through Congress. So the destruction of the destruction of the East Wing and the First Lady's area of the White House that is to build a ballroom is a literal stealing of congressional powers that involve the purse and involve the territories and properties of the United States. And so if, anybody's like, well, where does it say in the Constitution that Congress is in charge of the property? Well, the United States, the White House is the most important property that Congress is in charge of. And it says in Article 4, Section 3, that Congress is the one who makes the rules and regulations respecting the territories or properties. So just tearing down a wing because you feel like it is actually against the Constitution. It's not constitutionally allowed. Now, what everybody who's ever fought with police over the restraining order piece of paper knows is that just because something is or is not allowed doesn't mean that an abuser will or will not do it. So this says you can't destroy property of the United States unless Congress has let you do it. And then we go on to Article 4 that says the United States shall guarantee to every state in the Union a republican form of government and shall protect each of them against invasion and on application of the legislature or of the executive when the legislature cannot be convened against domestic violence. So if you send in troops to attack protesters and to rile up domestic violence at the same time that you've also shut down Congress, it makes it easier for the executive to have kingly powers so that they can then send more troops against the domestic violence that they have actually caused, and that the Congress is not there to stop them from the overreach. So Article 4 is a 4-section article. Article 5, the Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or on the application of the legislatures of 2/3 of the several states shall call a convention for proposing amendments, which in either case shall be valid to all intents and purposes as part of this Constitution when ratified by the legislatures of 3/4 of the several states, or by convention in 3/4 thereof, as the one or the other mode of ratification may be proposed by the Congress, provided that no amendment which may be made prior to the year 1808 shall in any manner affect the first and fourth clauses in the 9th section of the first article, and that no state without its consent shall be deprived of its equal suffrage in the Senate. Well, that's a mouthful. So let's see. What do we got here? We need 2/3 of the houses to propose amendments to the Constitution. 2/3 of both houses. On the application of the legislatures of 2/3 of the several states, we can call a convention for proposing new. So if 2/3 of the House isn't possible, the state legislatures is another way. This is the convention of the states that you hear about. And then shall be valid to all intents and purposes as part of this Constitution. So if they can get it added through a convention of the states or through Congress, they can make a new amendment. That's what this one is saying. And then there's the provision, and that is way outside of our realm of even caring, because we do not live in 1808. But if we are interested in what it actually says, 1808 shall in any manner affect the first and fourth clauses in the 9th section of the first article. So we go back to the 9th section of the first article. So we find Article 1. Then we scroll, and I flip, because I'm using an actual book, to Article 9. And it says the first and fourth clauses in 9th section of the first article. So then we count first and fourth. 1, 2, 3, 4. Okay, so the first is the migration or importation of such persons as any of the states now existing shall think proper to admit shall not be prohibited by Congress prior to the year 1808, but a tax or duty may be imposed on such importation not exceeding $10 for each person. So prior to 1808, the states are allowed to import people. That is a slavery rule, and it is like vagrantly being stated that we were not going to amend that prior to the year 1808. It's questionable after 1808, but before 1808, you can definitely bring more slaves into a place. And after 1808, we are going to add a tax so that the state can make money off of slavery. And then we go to Clause 4, no capitation or other direct tax shall be laid unless in proportion to the census or enumeration herein before directed to be taken. And that one is amended on the 16th Amendment. Okay, so that one says you can't tax until after you do a census. So if you are ever one of those people that's like, oh, there's nothing wrong with censuses. Censuses are good for us. We need to know all the stuff that you can learn in a census. Censuses have been around from the beginning of America. One of the things you should know is that they have always been weaponized by the government against the people. So the more categories that the government adds to a census and expects you to fill out, or you're in violation of laws, is the more prying that they're doing, and the more that you answer that is the less privacy you have. So it works like that. If you answer all of the questions on a census that you think are innocent, you're literally waiving your right to privacy. You're waiving your Fourth Amendment. And we haven't gotten to the amendments yet. We're still in the articles. So that was the end of Article 5, which is literally the article that tells you how to get new amendments. I am reaching the 20-minute mark, and my throat is starting to hurt again. So we are going to, as you can hear from my voice, I'm getting scratchy. We're going to stop here, and we're going to, oh, we are so close to the finish. Okay, we're just going to push through. We're going to push through, and that will finish off the articles. Okay, so this is Article 6. All debts contracted and engagements entered into before the adoption of this Constitution shall be as valid against the United States under this Constitution as under the Confederation. Right there. You may or may not be aware that before the Constitution of the United States was ratified, we had a confederation of the United States, and this is not the Confederate Armies of, or the Confederate States of America. This is the Confederation of the United States. It was the original Confederate States of America, and the Constitution was considered to be weak. So what they're saying in this first paragraph of Article 6 is that anything that that original group did as law still stands under this new Constitution. That changing from a confederation to a constitution doesn't change the arrangements that they had made prior to that change. So this is saying we're changing what we're calling ourselves, we're updating our operating procedures, and we're holding all of our prior debts as legitimate. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land. And the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. So, state judges before supreme judges, unless it's something that falls in the origin of the Supreme Court and not the appellate of the Supreme Court. And it says that this stuff, all this federal stuff, is the supreme law of the land. So anytime that a federal law comes into play that is based on international treaty, we're imposing international rules on America. The local judges are supposed to be bound in every state to enforce that through their readings of the law and their enforcement and punishments or lack thereof. So then it says anything in the Constitution or laws of any state to the contrary notwithstanding. That seems like a double negative and could be confusing. Anything in the Constitution or the laws of any state to the contrary notwithstanding implies if there is a contrary constitutional law or a contrary state law that the supreme law of the land thing doesn't hold. But it's also, like I said, double negative, so then it could be implying that it does hold. So this is one of the first absolutely ambiguous sentences we've actually come to. Anything in the Constitution or laws of any state to the contrary of these supreme laws of the land, notwithstanding. So that says to me, if a state or the Constitution is changed, there's a conflict and they're contrary, then one of them isn't standing. And it sounds like the supreme law is the one not standing. But that's really, like, this is one of the nuanced areas where you would want to get that dictionary out and look up notwithstanding and see what notwithstanding meant in the 1800s, which I don't have my dictionary open today because I didn't think I was going to come off something like that. We'll look into that one later, and we're just going to finish real fast. The senators and representatives before mentioned, and the members of the several state legislatures, and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution, but no religious test shall ever be required as a qualification to any office or public trust under the United States. Well, well, well. So the whole Christian nation shit just fell flat on its ass because no religious test shall ever be required as a qualification to any office or public trust under the United States. Does it say we're a Christian nation in the Constitution? No, it says no religious test shall ever be required as a qualification to any office or public trust under the United States. So everybody takes an oath to the Constitution. There is no preferred religion, and that is specified in writing in Article 6 of the Constitution. You take an oath to the Constitution, you will uphold the Constitution. You are not testing people for their religious beliefs, or you're in violation of the Constitution. Article 7. The ratification of the conventions of 9 states shall be sufficient for the establishment of this Constitution between the states, so ratifying the same. Done in convention by the unanimous consent of the states present the 17th day of September in the year of our Lord 1787, and of the independence of the United States of America, the 12th in witness whereof we have hereunto subscribed our names. So they just said no religious test, and then they say that they are signing this in the year of their Lord. They all had different religions. One might have been Quaker, one might have been a deist, one might have been agnostic. But they're saying that there's no preference. They are all equals under this because they have sworn an oath or an affirmation to be bound by the Constitution. So we have George Washington, the president, and a deputy from Virginia. We have New Hampshire, John Langdon and Nicholas Gilman. Massachusetts was Nathaniel Gorham and Rufus King. Connecticut, William Samuel Johnson and Roger Sherman. New York, Alexander Hamilton. New Jersey, William Livingston, David Brearley, William Patterson, and Jonathan Dayton. Pennsylvania, B. Franklin, which I'm assuming is Benjamin Franklin, Thomas Mifflin, Robert Morris, George Clymer, Thomas Fitzsimmons, Gerald Ingersoll, James Wilson, and this is an abbreviation, G-O-U-V Morris, but I don't know what it's an abbreviation of. Delaware, George Reed, Gunning Bedford Jr., John Dickinson, Richard Bassett, Jacob Broom, Maryland, James McHenry, Anne of St. Thomas, Jennifer, Daniel Carroll, John Blair, Virginia, John Blair, James Madison Jr., North Carolina, Hubert Williamson, South Carolina, J. Rutledge, Charles Pickney, Pierce Butler, Georgia, William Few, Abraham Ball, William Secretary. In convention day, September 17th, the states of New Hampshire, Massachusetts, and Georgia resolved that the preceding Constitution of the United States, and that it is the opinion of this convention that it should afterwards be submitted to recognition of its for their assent and ratification, and that each convention assenting to and ratifying the same should give notice thereof to the United States in Congress assembled. Resolved that it is the opinion of this convention that as soon as the conventions of 9 states shall have ratified this Constitution. Stop, guys. Stop. Shall have ratified this Constitution was where I just moved my face and now I lost my place. Looking at my dogs barking. Crap. I really did lose the spot. Resolved that it is the opinion of this convention that as soon as the conventions of the 9 states shall have ratified this Constitution, appointed by this have the same, and a day on which the electors should assemble to vote for the president, and the time and place for commencing proceedings under this Constitution, that after such public electors should be appointed and the senators and representatives elected, that the electors should meet on the day fixed for the election of the president and should transmit their votes certified, signed, sealed, and directed as the Congress to the Secretary of the United States in Congress assembled, that the senators and representatives convene at the time and place assigned, that the senators should appoint a president of the Senate for the sole purpose of receiving, opening, and counting the votes of the president, and that after chosen, Congress, together with the president, should without delay proceed to the execution of this Constitution by the unanimous order of the convention, and George Washington, President. W. Jackson, Secretary. So that concludes the articles and the convention resolution for the Constitution. So we're going to call it there. Thank you for following us today, and hit the like and subscribe button if you like this content. Thank you.